Greetings, Earthlings! Hello, entrepreneurs, inventors, artists, authors, actors, computer programmers, businessmen and women, and other creative types. My name is Michael Folise. I'm an adjunct professor of intellectual property law here at Case Western Reserve University and a practitioner in residence at the Veale Center for Intellectual Property and Entrepreneurship. What we're going to do today is to talk about intellectual property law, what it is, and why you should care. Intellectual property is generally defined as patents, trademarks, copyrights, trade secrets, and the right of publicity. But why should you care about this? Well, a patent will prevent others from making, using, or selling your invention. A copyright will prevent other people from copying your computer programs, your advertising materials, your packaging, your manuals, and your written instructions. Trademarks will prevent other people from confusing the public into thinking that their products come from you. And trade secrets will prevent a departing employee from walking out the door with your customer list, your secret recipes, your technical drawings, and going to another company and using them to compete against you. Moreover, if you have these rights and any of these horrible things do happen, you can stop them and collect damages for infringement. Patents, trademarks, and copyrights and trade secrets are very different. And here's the most important fundamental difference. Trademarks, copyrights, and trade secrets are rights that you can generate on your own. But for patents, you have to apply to the national government of whatever country you're in and get an issued patent before you can have any enforceable rights. So there are three kinds of patents. What we call utility patents, the Patent Office calls them non-provisional applications, design patents, and plant patents. Utility patents protect the way the inventions work, the way they're made, and the way they're used. Design patents protect the way inventions look, and more specifically, the aesthetic appearance of articles of manufacture. And plant patents protect sexually reproduced plants. There's also something called the Plant Varieties Protection Act, which protects asexually reproduced plants, but this is a family video, so we're not going to talk about that. So what kind of things can't patents, trademarks, copyrights, trade secrets protect? Well, with respect to patents, and specifically utility patents, a patent cannot protect any abstract idea or method of doing business or organizing human behavior, but it can protect things like devices, machines, industrial processes, even living organisms. The polyploid oyster was the first patented living organism. And to some extent, it can protect computer programs to the extent that they either do something in the real world, like opening up a tire mold, or make a computer run better. Design patents, as I said previously, protect the aesthetic appearance of articles of manufacture, like chairs and automobile bodies and belt buckles and things like that. But in no case does a design patent cover an aesthetic feature that's totally dictated by function. With respect to trademarks, a trademark is anything that identifies a single source for goods or services, and then we call it a service mark. It can be a word, a phrase, a logo, a package design, a restaurant decor, even an aroma, or a series of tones like the MBC tone. But in no case can a trademark or service mark cover a generic designation for a product, like shoes for footwear. Copyrights protect the expression of an idea that's embodied in a work of authorship, and specifically when a work of authorship is fixed in a tangible medium, like taking pen to paper or taking a photograph on acetate or digital film. Once it's fixed in a tangible medium, you have a copyright. What do trade secrets protect? Trade secrets protect, as I said before, confidential business information, which provides the owner with an economic advantage, and for which reasonable efforts have been made to keep the secret just that, secret. So what kind of things don't trade secrets protect? Well, trade secrets don't protect anything that can be reverse engineered, or has been reverse engineered, or isn't kept secret. Copyrights don't protect abstract ideas, only the way those ideas are expressed in a tangible medium. And trademarks don't protect generic things. Patents don't protect abstract ideas. How do you acquire these rights? Well, as I said before, patents are only acquired by filing an application with a national government and having the government review that application and then issue the patent. Until the patent issues, there's no rights. What does an invention have to be patentable? Three things. It has to be new, it has to be useful, and it has to be unobvious to a person of ordinary skill in the art to which the invention pertains. What does novelty mean? Well, novelty means that there's nothing identically like the invention that's been sold, offered for sale, or publicly used anywhere in the world prior to the filing date. Useful means it's not a perpetual motion machine or an abstract idea. The third thing, obviousness, is what we argue with the Patent Office about most of the time. So what does obviousness mean? Well, it's a little bit of a subjective standard. It means that if a person of ordinary skill in the art could put together 2 or more prior art references and arrived at the claimed invention, then it's not patentable. Well, how many references? Well, if only 2 have to be put together, that might be a difficult rejection to beat in the Patent Office. But if the Patent Office has to put together 5 or more references to come up with the claimed invention, it's pretty obvious, if I could say that the Patent Office is using the claims as a roadmap to assemble the prior art, and that's not permissible. What do you have to do to have a valid trademark? Well, unlike patents, you can acquire trademark rights merely by using the mark on goods and transporting them in Congress controlled by Congress. That's anywhere in the interstate system, with a foreign nation, or with an indigenous native tribe. What else is required? Well, you have to be the first one to use that mark in commerce. And you begin to generate trademark rights market area by market area. The federal government and state governments give you an advantage if you file an application for registration, which again goes through a process of examination. And that is that if you file a federal application today and your trademark registration issues a year from now, the courts will pretend that you were selling product in all 50 states on the filing date of your application. And that's a good reason to file at an early date. What about copyrights? Are there any deadlines there? Well, there are, but they relate to what your measure of damages are going to be. To make it simple, let's put it this way. If you apply for registration of your copyright before there's any infringement, you don't have to prove your damages. The court can presume they're somewhere between $750,000 and $35,000, and the court will award you your attorney's fees if you win. So having a pre-existing copyright registration makes settling a copyright infringement case much easier. What about trade secrets? Well, there's no real deadlines there. You simply have to make reasonable efforts to keep the secret just that, secret. We've talked about patents, trademarks, copyrights, trade secrets. We've talked about what they cover, what they don't cover, the standards for obtaining them, the rights conferred. They all have terms. Patents last for 20 years from the filing date if it's a utility patent, 15 years from the issue date if they're a design patent. Copyrights last for the life of author, plus 95 years, thanks to the Sonny Bono Copyright Extension Act. And trade secrets will last indefinitely. With respect to trademarks, there are some post-registration fees that have to be paid between the 5th and 6th anniversary, and then renewals happen every 10 years, but they can last forever. For example, Coca-Cola is said to keep the formula for the Coca-Cola syrup secret in the vault in Atlanta, and only ships out syrup to the distributors where they mix it with water and sugar. Had Coca-Cola filed a patent application and the patent had issued, the formula on Coca-Cola would have no longer been exclusive after the patent expired. So Coca-Cola made a good decision to keep that secret. Coca-Cola is another good example of a trademark. If you were to see a beverage truck with a red background and a white swoosh going through it, you would know that carries the cola beverage you're familiar with. Or if you saw a wasp waste fluted bottle full of a cola-covered beverage, you know it was the one that you like. So there are various ways, in addition to the phrase, Coke is it, it's the real thing, which are protected as trademarks for slogans, in which trademarks can come into play in your business. I hope this has helped you out, but we do need to talk about a few more things. We'll go into some more details about critical deadlines for intellectual property. When do you have to get your patent application filed? And what about filing outside the United States? But if you want to learn about that, you're going to have to stay tuned and watch for our next video. Until then, be wise and how does that go?